shares. We're going to scoot straight over to the share screen section, and I'm going to pop up the presentation for today. And we're now in recording mode in case you didn't get that notification. Today's section is on legal aspects of recruitment. So yesterday we talked about legal aspects of staffing. So a lot of the things that we talked about yesterday that had to deal with things like the Employment Standards Act were sometimes general about the Employment Standards Act, how it applies to all employers and employees. And a lot of the content yesterday was with respect to the very specific aspects of various employment legislation across the country and how it applies to recruitment and staffing companies. Today, most of what we're going to talk about is going to be applied equally to all employers, but very important that you understand it so that you can be on board with respect to your compliance with various aspects of the legislation. We're going to go really quickly through the first few screens because they're very similar or the same as they were yesterday. But just in case anybody wasn't on the call yesterday, I'll go really quickly through it. There are 5 modules that exist in your CPC. This is, for most of you, your second module in this session. The other modules include business practice and ethics, health and safety, recruitment and selection. And we also have a new module coming out later this year on sales, which is optional for you. And so it'll be specifically to sales in the recruitment and staffing services industry. And of course, at the end of you completing those 5 modules, you have the opportunity to complete your CPC challenge exam, which is a multiple choice exam. And I just remind you, you do not need to memorize very specific or unique aspects of the various legislation. It is important that you understand what legislation exists and how it applies to you. And keep in mind that from province to province, there will be subtle differences in various legislation. And also, it changes. We spent a lot of time yesterday talking about how legislation is created and affected and changes in federal and a provincial level. And so just because I tell you something today doesn't necessarily mean it's going to be applicable tomorrow. As a matter of fact, as we go through each of these sessions, and we offer them twice a year, I have to go back myself and take a look and see what bills are in the queue and what has passed and what might have changed or what regulations have been updated. We talked yesterday about the mission statement of the organization, so we won't repeat that for you again, and also that you are employees or senior management or owners of a member company. Access memberships are for companies, not for individuals. But if you are an employee, an owner, or a manager working within a member company, then you have access to all of the access resources that are available, including this CPC sessions, but also includes conference and chapter meetings and the resources for brochures and other learning materials and resources that are available on the Access website and through the Access office. Today, we're going to talk a little bit about human rights legislation and how it affects the recruitment and staffing services industry. We're also going to talk about the principles of diversity, equity, and employment equity. And we're going to get into some privacy issues for PAPITA and how that might also affect you in the collection, retention, and use of information. Again, I want to remind you that each of the sessions that we're going to talk about have got federal and provincial implications. You, being in the recruitment and staffing services industry, are covered underneath provincial legislation because we're not one of those designated groups such as banks and airlines and so on that fit under the federal legislation. But there is a unique relationship that exists between the federal legislation and the provinces. And so we'll talk about that from time to time. So we're going to kick it off with human rights. And I'm going to kind of remind you that, well, first off, human rights really has to deal with the overarching principles of dignity, respect, and equality. And we want to remind you that we've got different levels of legislation. We talked yesterday about the Charter of Rights and Freedoms, and we talked about the federal, how federal legislation is created. And then also we talked about the relationship of the provinces. So what we have is the human rights acts that exist both federally and provincially. So the first human rights acts that were created were federal legislation that applied only to the federal government and to federally regulated industries. And then each of the provinces was given the opportunity to create their own provincial legislation to reflect the uniqueness of their province. But we're going to find, and I'm going to use the federal legislation and probably Ontario's legislation. I'll use different examples of how it was applied in Alberta or British Columbia or Quebec. I'll give you different examples, but the underlying principles for human rights in Canada between the provinces and the federal government are fundamentally the same. They cover the same things. And also, when a decision is made in a court, we talked about common law decisions. When a decision is made in a court concerning a provincial issue, it can affect the other provinces and it can affect the federal human rights. So it's not common unless it's very specifically written differently to mean something different from province to province, and that is very rare. So it's very rare that you would see somebody say, oh yeah, that would be covered under the Human Rights Act in Alberta, but it's not covered under Ontario. Typically, decisions that are made because the overarching principles are consistent from province to province and federally, that any decisions that are made in the courts finally make their way across the country to the other provinces. So we have the Canadian Human Rights Act, what it's called. We have the Charter of Rights and Freedoms, which we talked a lot about yesterday, which talks about individuals' rights relative to how that might apply to the rights of the whole. And we also have various provincial legislation. So, for example, in Ontario, it's called the Ontario Human Rights Code. Don't be confused between the words act and code. They mean the same thing. Different provinces tend to use different words to describe acts and codes. If they pass through a provincial legislature, then whatever they call it, it has the same amount of force or legal authority. So the human rights legislation that applies to all companies in Canada with respect to employment. So the human rights codes and acts talk about a lot of things. They talk about housing. They talk about access to services. They talk about all kinds of things, but certain aspects of it are very specific to employment. So the human rights acts or codes refer to things like recruitment advertising, the kinds of things that you can and should or should not put into recruitment advertising. It talks about referrals of candidates, how that can and should not be done. It applies to promotions and demotions. It applies to training, the content of training, as well as access to training for various people inside your companies and your customers' companies. Human rights codes and acts refer to wages, so that we have equality in the application of how wages are set. It refers to things like application forms, the interview process. So very often when we do interview training, recruitment and selection training, we are always, very often there is content there that refers to the human rights acts or codes. And we are always cognizant of or aware of the kinds of questions that we can and should not ask. And sometimes it might seem very innocuous when we ask people certain questions, but they might inadvertently or unintentionally be promoting answers to questions and disclosing or uncovering information about a candidate that delves into the areas of prohibited grounds, things that we're not supposed to take into consideration while we're conducting an interview and making our selection. And so interviewing is a pretty critical part of it, and it's important that we get training in our professionals in the way we conduct our interviews. The opportunity for apprenticeships is covered under human rights. Transfers of employees from one location or one department to another, location to another within a company and its subsidiaries, and all other matters respecting employment. So if we look at sort of the definition of discrimination, discrimination is an action or a decision that treats a person or a group of people negatively for reasons such as race, age, or disability. There are other reasons. And these reasons are known as or referred to as grounds of discrimination. So we've referred to these 11 grounds as prohibited grounds. In other words, we're prohibited from entering those areas of discussion, collection of information, or to use that information in our decisions with respect to any of those things on the previous screen. And so these prohibited grounds cover areas of race, national or ethnic origin, color, religion, age, sex, sexual orientation, marital status, family status, and disability, and the unique concept of convictions of which a pardon has not been granted. We're not going to spend a lot of time on convictions, but basically what this means is, yeah, you can take into consideration a person's criminal record when you're hiring them, so long as it's somehow related to the qualifications for the job, and so long as the person has not been granted a pardon or suspension. So without getting into the technicalities, a person after they've been convicted and served their term and they've gone through their parole, and after a certain amount of time goes by, they can apply for what's known as a pardon, which for all intents and purposes is the legal removal of that information from their record. However, it's not always totally removed, and some of that information is in the public domain, and they might even tell you that they were previously offense. And if a pardon exists, we're not supposed to consider that at all. The issue of sexual orientation was on the list, was not originally on the list when the Human Rights Code, Canada Human Rights legislation was originally conceived, and when the provinces started falling on board with their own individual human rights acts or codes. And then in 1995, in a case called Egan versus Canada, the Supreme Court of Canada, this originated, by the way, in Alberta, and it went through the Alberta courts and then rose to the level of the Supreme Court of Canada as it got appealed. The Supreme Court of Canada held that although sexual orientation was not originally listed as one of the grounds for discrimination, the Charter of Rights and Freedoms, Section 15.1, when it related to that aspect of the Charter, it constituted an equivalent ground on which a claim for discrimination may be based. So in this case, Vrend versus the province of Alberta in 1998, the court held that the provincial human rights legislation had left out grounds of discrimination for sexual orientation that is covered under the Charter of Rights and Freedoms, Section 15.1. So just to sort of explain what that means, is we recall yesterday we talked about the Charter of Rights and Freedoms as being the law, the big Canadian law that gives us under the Charter of Rights and Freedoms and the Canadian Constitution, which is the law of laws. It tells us who has authority over laws and what kinds of things they can make laws about. And so if we excluded the sexual orientation aspect from the human rights codes, we were in fact violating Section 15.1 of the Charter of Rights and Freedoms. And so by common law or a decision in court case precedent, it became included. And then following that, in the year 2000, Parliament passed Bill C-23, which codified or wrote down the fact that same-sex couples would have the same social and tax benefits as heterosexual couples in common law relationships. So whether you were married in a heterosexual relationship through a marriage license, or whether you were married in common law, Bill C-23 then extended that to say that common law marriages would extend to same-sex couples. And then in 2005, they went further and passed the Civil Marriage Act, which now allowed same-sex couples to also get a marriage license. So it started off that they were not named or included. The courts decided that they should have been, because we can't tell the difference between a common law heterosexual relationship and a same-sex relationship. Then the federal government in 2000 said, okay, we're going to put this in writing that it's the same as a common law relationship. And then in 2005, they went further to say that same-sex married couples could also get a marriage license and didn't have to only rely upon a common law relationship, but they could also be married anywhere in Canada. So this is an example, again, of how decisions and laws are created in Canada. We have got the law of laws, our Constitution, and our Charter of Rights and Freedoms that kind of sets the groundwork on what could and should and should not be covered, and by whom, and how those laws can be created. And then laws are written by our elected politicians and created through statute, and then courts challenge those laws, and they become court decisions that help to clarify things, and they become common law. And then very often, as we talked about yesterday in the province of Ontario with the Employment Standards Act, they codified and wrote into the code several different changes with respect to temporary staffing services and employment agencies. And in this particular case that I just gave you, wrote down in statute the rules with respect to same-sex couples. So when we talk about discrimination, we talk about two forms of discrimination. One of them is referred to as adverse effect discrimination. This is not the most common phrase that we hear. We hear the phrase systemic discrimination, which I'll get to next, very often in the news and in the media and in court cases. But adverse discrimination is like all-out discrimination. It is a policy or practice that, even though when it might have been put in place was intentionally or unintentionally designed to single out a person or a group of particular people in order to, that would result in unequal treatment. So this type of unintentional discrimination is called adverse discrimination. And so some adverse discrimination examples might be requiring an employee to wear a uniform, a promotional uniform or a particular kind of uniform that conflicts with a person's religious clothing requirements. We also look at adverse discrimination. So listen, I don't even know the total, it's still in the courts, but in the province of Quebec, they tried to pass a law, they have passed a law that prohibits employees of the government from wearing religious symbols. And that's being challenged in particular ways. And in this particular example, we're going to be more kind of settled. In terms of when I mean settled, I mean it has been already agreed in the courts and challenged and so on. So for example, the requirement to wear a uniform, in a chicken fast food place, where they have to wear a particular kind of, chicken hat, and a person is required under their religion to wear religious head coverings. And it's well established now that that they can be allowed to wear their religious head coverings and don't have to wear the chicken hat. Same thing goes with respect to, I'm going to give you a more specific example with respect to hard hats. And the RCMP had that example in British Columbia 2 decades ago with respect to wearing an RCMP hat opposed to religious head coverings. So something like the establishment of work schedules that uniformly rotate employees through a rotating schedule that don't take into consideration certain individuals' religious holidays would be considered adverse effect discrimination. So having a policy that either would require a person to work on their religious holiday, or that they can't work and they miss out on work because they don't come to work on their religious holiday, would be adverse effect discrimination. Standardizing office furniture and equipment for people who maybe have a disability or an injury, that would be considered adverse effect discrimination. So adverse effect discrimination is possibly a good policy that works well throughout the company, but doesn't work perfectly all the time. And as a result of that, we want to provide some form of accommodation to the people that we were unintentionally, that we did not intend to cause harm to. Whereas systemic discrimination is the kind of discrimination that we often hear about in the news because it's the big bad discrimination. So systemic discrimination is when discrimination happens because of business practice or a workplace policy or a government program. It's called systemic discrimination because this discrimination is not limited to a single incident or isolated case. It would systematically discriminate against a large number of people on a regular, consistent, or predictable basis. So we're concerned about systemic discrimination because it is considered by the company in their, or the organization in their policy, as a normal way to do things, but it may have a negative impact on those who are racialized or those who have disabilities or one of the prohibited grounds. And so when we see systemic discrimination, we say things like doing credit checks or background checks, criminal background checks on people, when it may not be necessary for the type of work that they're doing. I don't know why we would need to do a criminal background check on someone who lays sod and does work outside in groundskeeping, for example. Recruitment practices such as favoring or limiting word-of-mouth referrals might unintentionally, if we only hire friends and family, then we will only be hiring from potentially a very limited pool of people that are somewhat very similar and do not give access to the broader community. Steering applicants to certain jobs or assignments based upon their race or gender would be considered systemic discrimination. Historically segregated occupations or industries. So saying that only women can be nurses or only men can be firefighters, if that was some part of policy or unintentional process of evaluating people, that would be considered systemic discrimination. So job ads that use the words recent graduate, young, or energetic, or men only or women only, would be considered systemic discrimination. If we allow our customers to regularly tell us that they have preferences for people, it's not uncommon, for example, for people who maybe had experiences with a Filipino nanny at one point in time of their life to turn around and say to a home care company, we want a Filipino caregiver. And so accepting that order with that as that request for a caregiver to work in home care would be considered a violation of the Human Rights Act and systemic discrimination. Now, it may very well be that they had an experience with a caregiver at some point in time in their life who was caring and thoughtful and considerate, and that the client inappropriately and wrongly associated those characteristic traits, which are legal to recruit upon. You can't say we need people who have a proven background or experience of being caring, thoughtful, and considerate. That's legal. There's nothing discriminatory about that. But if you associate that to a religion or to a place of origin or to an ethnicity, then that would be considered discrimination. Customer customer, big data and algorithms that sort through applications. So we got to be concerned, or we got to watch to make sure that our applicant tracking systems aren't unknowingly or unwittingly doing something in the way that it sorts applications and prioritizing our applicants for us, that it isn't using something unintentionally that might be considered discriminatory. Personality tests, customer service tests, these kinds of tests, if they're used improperly, can be considered systemic discrimination. They're not discriminatory on the face of it, but they can be used improperly and would therefore then be considered systemic. So things like mandatory religious practices by people, English only rules, age-based limits, mandatory retirement rules, waivers that people have to sign with respect to some of the things in their employment contract, no fault attendant policies. I don't really know what that means. I think, no fault attendant policies might be something like 3 strikes and you're out. And of course, that would be considered systemic discrimination because it's maybe not taking into consideration a person's family status. We talked yesterday about all the various legal forms of leave. So if a person has critical illness or family emergency, those things are covered under the Human Rights Act. And so therefore consideration must be given to a person. And the law specifically says how many days that we have to protect a person for. And so if we had a policy that says if you're late for work 3 times, or if you are absent for work 3 times, you're fired, without giving consideration to those reasons that might be covered under the Human Rights Act or under provincial legislation, would be considered systemic discrimination. Light duty policies for only work-related industries. So if a person is injured outside of work, that's considered a disability. We need to accommodate them in some way. We all know, or I think we should know, that if a person gets injured at work, we need to accommodate them to have modified work to come back to work early so that they don't stay at home for 100% of the time doing 0 when they could come back and do maybe 50% of their previous job. So we know that we have to accommodate them in some way for work-related injuries, but not accommodating people for illnesses or injuries that came otherwise just through age or health or accident, could be considered discrimination under the prohibited grounds of disability. Pre-employment medical inquiries, if they have nothing to do with the work, then they're considered prohibited. So when we compare the two notions of adverse discrimination or systemic discrimination, where adverse discrimination is probably good policy that unwittingly or unintentionally might have an impact on a person, small group of people, we don't necessarily have to change the policy. We might want to look at the policy, determine whether we can make the policy better, but we simply have an obligation to accommodate the person who is unintentionally affected by it. Whereas systemic discrimination will consistently and persistently discriminate against people and a group of people in a way that may or may not have been intended. And in that particular case, if it's referred to as systemic, then we need to change the system so that it no longer discriminates against people. Now, I've used the word accommodation several times already. And so we use the term reasonable accommodation because you don't need to accommodate everybody for everything all the time. But we do need to be reasonable in what we consider to be accommodation, to make adjustments to the system or to the workplace or to the work environment or to our expectations so that we can reasonably accommodate a person concerning their religion or their employment with the company. So examples of reasonable accommodation might include things like expanding our advertising from Indeed to also include Aboriginal communities. We might find out that Aboriginal people who live in Aboriginal communities and with Aboriginal heritage might, for some reason, due to their heritage, their beliefs, their upbringing, their education, might only go to particular sites to look for jobs. They might have been told that that's how you look for a job. And that might be how they're best inclined to find a job within their own Aboriginal community. But in order to find jobs elsewhere, they might need to go to Indeed or go to newspapers or to other job fairs. And so one way that we can reasonably accommodate this systemic discrimination is to expand the places that we place our advertising. We can put advertisements in different languages so that we can appeal to people that don't only speak perfect English or read perfect English, if English is not a requirement for the job. We can have apprentice programs specifically designate older workers or disabled workers. Very often apprentice programs unintentionally only look at new hires and new graduates from various trade and technical programs. But they don't have to only be designed for people who are younger and who are recent graduates. So we need to take a look at how do we make our apprenticeship programs available to a broader scope of people. We all know about various software programs where you can speak and do voice to text conversion in keyboards, and phones that don't double click and have slower, more specific things on keyboards. And we can have larger monitors, and we can have spoken read text to people with visual impairments. So there's all kinds of ways that we can accommodate people to do their jobs. And so the other example I gave was people with religious practices working on days when they might need to practice their religious beliefs on Friday nights or Saturdays or Sunday afternoons. And so people, or through religious holidays. And so we can fairly easily change our scheduling so that we can reasonably accommodate people. There probably is. I don't know exactly what it is, but there's no real hardcore definition of reasonableness when we talk about accommodations. They look at things when we talk about reasonable accommodation on the context of what reasonable means. We look at all of the issues on balance. So, for example, if we had to purchase a $400,000 modification to a truck to reasonably accommodate a person to become a truck driver, that probably in a lot of cases wouldn't be reasonable to increase our cost on a one-person basis by $400,000. But we might be able to reasonably accommodate that person to work in dispatch so that they can work on the phone with a headset and that they can still utilize their knowledge and experience around trucking, but not have to spend $400,000 on modifying a truck. So we take a look at the total cost. We look at the revenue that is generated. We look at the benefit that worker contributes. We look at how many employees they have and how this can be integrated into the workforce. And so the reasonableness is on balance, all issues taken into consideration. And people will often argue that it is reasonable, and other parties might argue that it's not reasonable. And that's for a court to decide on balance when taking a look at all of the issues to take into consideration. We also talk about this thing called a bona fide occupational requirement, which is very often a BFOR, bona fide occupational requirement, is more of a Canadian phrase, but we often hear the exact same expression in the United States called a bona fide occupational qualification, so a BFOQ. So it's not uncommon for you to go to college or university or take a course and you're using a US textbook when we're talking about some of these issues, and they talk about them in terms of the qualification instead of the requirement. So a bona fide occupational requirement is a quality or an attribute that employers are allowed to use to consider when making decisions on their hiring or the retention of their employees that might otherwise have been considered discriminatory under human rights laws. So, for example, think of an example. An example might be that a Catholic school board for their religion class, might require a person to be Catholic. And I'm sure that if a person who was not Catholic, who wanted to teach that course, could potentially make an argument that, if they've studied religion in university, that they might have even better knowledge or experience, but the Catholic school board might have a good case to say, no, you can't teach Catholicism unless you're Catholic. And so there would be an example where somebody might say, that's a bona fide occupational requirement. Now, I think back in the day, maybe in the 70s and in the early 80s, people would make the case that only a male coach could coach a male team because they needed to have access to the change rooms. And those have been challenged in courts, and it's been decided that we can accommodate female coaches and female media around male team dressing rooms. It's pretty easy to have people spoken to when you just announce that they're coming into the room, or to have an area outside the room where the media can interview the players. That's why nowadays in hockey, the interviews aren't done sitting at the bench, or in football, that they come outside and they sit at a press table or they stand in the hall and do their interviews. Those were very reasonable accommodations. But at one point in time, people would have thought that's a bona fide occupational requirement. You need to be of a particular gender in order to do that particular job. And a lot of those things have been shot down. So what are some examples of bona fide occupational requirements or situations? So here's a story, an accommodation. Mr. Christie was employed at a dairy pool that became the and Mr. Christie became a member of the Worldwide Church of God in 1983. So this is an old case. Sometimes we use, it's not that we're being outdated. Very often when we give these courses and we teach things to you, we give you some of the first cases, and then more cases rely upon those first cases until it becomes the rule of the land. So this is one of the first cases in Canada under this particular example. The church recognized a Saturday as a Sabbath and 10 other holy days throughout the year. Members of the church are expected to not work on these Sabbath days and holy days, and Mr. Christie asked his employer for permission to take unpaid leave on Tuesday, March 29th and Monday, April the 4th, because those were holy days in his church. He was granted leave for the Tuesday, but denied leave for the Monday, because Mondays then were especially busy days at the dairy pool. So what would happen is milk would arrive over the course of the weekend. Unpasteurized milk would arrive from various dairy farms over the course of the weekend, and they couldn't allow it to sit for very long before it got pasteurized and shipped out and sent to market. And so in order to accommodate this so that milk wouldn't go bad, they were not giving people Mondays off to prevent spoilage. So Mr. Christie put his religion above that requirement at work, and he didn't show up from work without permission, and the dairy pool terminated his employment. So the Board of Inquiry ruled that Christie was discriminated against because his religious faith had not been accommodated. They thought he could have been reasonably accommodated by modifying his schedule and putting other people on for that particular Monday, or for Mondays, for that particular Holy Monday. And then the decision was overturned in the Alberta Court of Queen bench. But then I think it rose to a higher level and it was overturned again. So what happened here? So what happened was the first court read the Alberta legislation, human rights legislation, verbatim. And a lot of the changes in other court decisions hadn't already been made. And as a result of that, well, they first said, that's discrimination. Then when it was appealed, they appealed it based upon the absolute wording of the legislation. And so the appellate court said, yeah, in law, that, that's not accommodated for specifically, and it's not a reasonable accommodation. Then it rises to a higher court, and they decide that, yeah, overall, there was opportunity for them to reasonably accommodate people. So they took into consideration the bona fide occupational requirement that a person should and had to work on Mondays. They took into consideration the reasonableness of accommodating him, and they determined that it is somewhat reasonable. They took into consideration the fact that it was adverse effect discrimination, that it was a policy that was not intended to discriminate against him, but it did. And so then we come up with some other cases further down the road. The Canadian National Railway versus the Human Rights Commission in Canada. So let's take a look at this one. This one was a precedent-setting case. The Supreme Court of Canada decided the requirement of wearing a hard hat is not a bona fide occupational requirement in this particular case, and amounted to discrimination on the basis of religion. So now we've got pretty much the exact same circumstance. We've got a person asking to be accommodated. There's a policy in place. At the dairy, there was a policy in place that you had to work on Mondays. And in this particular case, there's a policy in place that says you have to wear a hard hat. And so this Sikh worker wanted to wear a religious headdress and did not want to wear the hard hat. So what happened? They decided that they needed to accommodate the person because, and as it went through the courts and it rose to the Supreme Court of Canada, there was no shortage of maintenance electricians at the CNR, at the Canadian. They had lots of maintenance electricians. And so moving people around was very possible. Mr. Binder was not a unique or specialized employee. It's not like he's the only person who could do that job. And every time he has to be accommodated for not wearing a hard hat, that they didn't have other people who could do the job. And the employer safety policy would not be jeopardized by Mr. Binder be giving an exemption because Mr. Binder was willing to be located to posts where it really didn't matter that much if he wore a helmet. It wasn't putting his health and safety at risk if he performed certain kinds of jobs where there was no risk of him getting whacked in the head. And he was willing to assume those duties as a maintenance electrician in these other locations, performing other electrician duties where there was no risk of, or little risk of, head injury. He was able to perform his job effectively and efficiently without the hat, so it didn't cause a burden on the CNR. And it didn't put at risk his other employees or the general public because he wasn't wearing a hat. So the risk of injury to Mr. Binder if he didn't wear a hat was very negligible. And so in this particular place, the courts decided that the notion of reasonable accommodation was possible. That it was very reasonable to just say, hey, you're going to work at station A where there's nothing above head or nothing going to hit you in there. You're doing paperwork or whatever. And the other employees didn't complain about it. It didn't cause financial hardship to the company. So in that particular case, they found that there was a reasonableness in allowing him to wear his religious headdress opposed to wearing a hard hat. So in that particular case, that was called adverse discrimination, not systemic discrimination, that it adversely affected him in a very specific way, and that they could take a look at the bona fide occupational requirements, and they'd say, it was only a bona fide occupational requirements at some workstations, not all workstations. It was reasonable for reasonable accommodation at some workstations and not others. And so as a result of the adverse discrimination application, they were able to make changes in his particular grounds. So which of the following are not discriminatory practices? So denying someone goods or services, facilities, or accommodation based upon a prohibited ground. Well, we didn't talk about other aspects of the law. We've been focused on employment law, but denying someone goods or services or accommodations is considered discrimination under the law because it's under a prohibited ground. Denying an employment opportunity based upon a bona fide occupational requirement. Remember, a bona fide occupational requirement means a real, truthful requirement. some people say bona fide. It's come from the expression, a Latin expression. So this bona fide occupation, if it's a bona fide occupational requirement and it's proven to be bona fide, then in fact you can make that a requirement. And in fact, you can, we actually wouldn't call it discrimination anymore. There is a prohibited ground that in this particular case, we're allowed to consider to be an aspect of hiring. So it's not discrimination. Denying paying men and women differently when they're doing work of the same value, that would be discrimination on gender or sex. Retaliating against a person who has filed a complaint with the commission or against someone who has filed a complaint on their behalf. So yesterday we talked about the notion of reprisal. So in all of these laws, whether it's employment standards, workplace health and safety, human rights, when we have got when a company or people reprise against someone. So in other words, sorry, my dog's barking in the background, which means someone's outside my house. If someone, which means punishing them or harming them because they made a complaint that they were fully within their rights to complain about. And by the way, you don't need to be right in order to lodge a complaint. And it is wrong, it is a reprisal to penalize a person if they made the complaint but thought they were right. They can make a complaint under the Human Rights Act, not win their complaint, but we still can't punish the person or reprise against them. That would be considered wrong, a violation of the Human Rights Act, and comes with heavy penalties to the employer. Harassing someone is considered a violation of human rights and is specifically covered in some areas. As a matter of fact, in the province of Ontario, workplace violence and harassment protection, although it's covered under human rights, if that harassment has anything to do with any one of the prohibited grounds. But in Ontario, and I believe in other provinces, they've extended it under workplace health and safety. Sorry, I said workers' compensation. Under workplace health and safety legislation to protect people from being harassed or violently acted upon at work, even if it doesn't have to deal with a prohibited grounds. Any form of harassment or violence is protected. It just so happens that the Human Rights Commission, Human Rights Act protects people from being harassed if it's under prohibited grounds, and workplace violence and harassment protection legislation under workplace safety laws protects people from being harassed for any reason whatsoever. Here's another case. In a unanimous decision, this is the Western School District versus Mr. Smith. In a unanimous decision, the Supreme Court of Canada restored the decision of the BC Council of Human Rights, which found that Mr. Smith was discriminated against by both his employer and his union because of his religious beliefs. So Mr. Smith, now the reason why it rose to a higher level is because the employers appealed it and they lost. So the lower court said, yeah, that's discrimination. The school board appealed it. They went to the, I believe this was in Alberta. They went to a higher level court in Alberta. They lost. They appealed to the Supreme Court. They lost. So Mr. Smith was a custodian in a school board, and he's a Seventh-day Adventist. His religious belief prevented him from working from sundown on Friday to sundown on Saturday. The works, I won't read it to you. I'll just tell you what happened. So basically what happens is the school board has got a rule or a policy, and the union has got it in their union agreement that whenever they rent out the school at nighttime to groups, Cub Scouts, Girl Guides, volleyball teams, floor hockey leagues, that they need to have a custodian on site for safety and other operational reasons. Unlock the doors, clean things up, make sure the toilets work. And so the union agreement allowed for the school boards to assign people to work in the evenings, and they would rotate various custodians through those evenings and day schedules. This particular custodian, Mr. Smith, didn't want to work, claimed that he was not permitted to work for religious reasons on Friday nights when they rented the school out. And they said, well, you can't keep your job if you can't work on Friday nights. And so he went to the Human Rights Commission. School board originally lost. They lost, and then they lost. And the whole notion there was that they took a look at how many custodians worked in the school boards and how many nights of the week they rented those schools out. And they found that it really wasn't difficult for them to say, hey, you can work on Monday nights when we rent it out to the floor hockey group or to the whatever group. You don't have to work on Friday nights. And they had enough custodians through, and he was willing to lose hours if he didn't work on Friday nights and give his hours up to other people. And so he was allowed to keep his job. The school board was required to accommodate him. And of course, they would treat that policy now as systemic discrimination because it was a system or a policy that they were told by the courts, various levels of courts, that it systemically discriminated against people because of their religious belief. So they would have to change their policy, not only in adverse effect, discrimination, accommodate him, but change their policy entirely to accommodate anyone and everyone who had same or similar religious beliefs. Here's another situation of systemic discrimination that is more, my goodness, it's even more in the media recently because Hockey Canada has been under such scrutiny with respect to its sexual harassment allegations with respect to some of their coaches and team players, and some of it coming to light in the last year to 2 years. So they've lost their funding, they've lost support from the federal government, they've been required to dissolve and reorganize and get rid of their board of directors and their coaches, all kinds of things since this policy decision took place. This was many years ago, where Hockey Canada agreed to make changes to protect their young players in Ontario from discrimination and harassment based upon a player's transgender status. So these changes resolved around human rights applications filed after facing difficulties in local arenas because transgender individuals were looking for accommodations with respect to change rooms and the ability to join certain teams. And so the resolution was made by Hockey Canada after going through the court process through the Human Rights Commission tribunal to provide training to all of its Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment. It also amended its Ontario co-ed dressing rooms policy, which would be publicly posted on their websites and in all of their hockey arenas, so that a player has a right to use a dressing room that corresponds to the player's self-identified gender. And a player shall be addressed by the player's preferred name and referred to by the pronouns corresponding to a player's self-identified gender. And a player is entitled to privacy and confidentiality with respect to their player's trans status. So they're not supposed to notify people that, you know, this particular player is a transgender, self-identified transgender person. And information about the amended policies would be available to all their staff, their parents, their guardians, and all the facilities throughout Ontario. So this was an example where a complaint was made to the organization. The organization was unable to resolve it themselves, and so it escalated to the Human Rights Tribunal, where the Human Rights Tribunal made a decision. Now, just so you know, that's the normal course of action. That under human rights legislation, an individual has got an obligation to go to their employer or the responsible party directly first to see if they can be accommodated. If they are not accommodated and feel that it is still a violation of the Human Rights Act or code in their jurisdiction, then they can raise it to the level of the Human Rights Tribunal. The Human Rights Tribunal will attempt to settle it through mediation. If the parties cannot agree upon a mediated solution, then it'll rise to the tribunal for decisions, and they have a hearing with testimony like a court case. And the tribunal will give its judgment. And of course, if each party would have the opportunity to appeal that to appellant tribunal, and they would have the right to appeal that to the if it is accepted by the Supreme Court of Canada, if it were to rise that high. Most cases with respect to human rights are settled at complaint stage. And they're reasonably accommodated. And almost always what we find is that employers become educated, and once they understand their obligations under the Act, they act appropriately, but not always. So let's do a little multiple choice questionnaire here. A policy provides benefits to some married couples, but not to others. This may be a case of discrimination based upon family status. A person is identified, a person is denied a job, a person is denied a job because of a previous conviction for which a pardon has already been granted or a record has been suspended. So that would be a discrimination based upon pardon and conviction. One of the 11 prohibited grounds. Sorry, I'm just moving some things around on my screen. An employee has a reaction to dust and chemicals at work and needs to take 2 days off. The employee needs the company's address for a WSIB form to be filled out because it's considered a workplace injury, but her supervisor refuses to give the information that she needs to fill out the form. So she's told there is no place for her to work at the company because they don't want her filing workers' compensation and insurance board claims every other day. So they're saying that she's abusing her privilege to file something through workers' compensation, and that would be considered discrimination based upon a disability, notwithstanding the fact it is a violation of their provincial workers' compensation, WSIB, and Ontario Workplace Safety Insurance Board policies. A female employee with an excellent performance record announces that she is pregnant. Immediately, her employer begins to identify performance issues that led to her dismissal. We use the word may here because it's possible that she changed her behavior, but not likely. So this may be a case of discrimination based upon family status. So if the person continued to perform well just the way they always performed well, and it wasn't, and their performance was in no way related to their pregnancy, then that would be considered discrimination based upon family status. An employer assigns her employees to weekend shifts without recognizing that some employees observe the Sabbath and cannot work on those days. This may be a case of discrimination based upon, of course, religion. An employer's physical fitness requirements are based on the capabilities of an average 25-year-old. I don't know what that means because I don't know if when it comes to physical abilities, there is an average 25-year-old, but I think that they're saying that maybe an average 25-year-old has better typically cardiovascular system or strength or something. It's based instead of on the actual requirements of the job. This may be a case of discrimination based upon job. So if they ran an ad saying you must have the skills of an average 25-year-old or something, then that would be discrimination on age. True or false? Is harassment a form of discrimination? The answer is yes. Harassment is a form of discrimination. It involves any unwanted physical or verbal behavior that offends or humiliates the person. Generally, harassment is a behavior that persists over time and is a series of incidents, but sometimes can be a one-time severe incident, which has a lasting impact on the individual. So a serious one-time incidents can also be sometimes considered to be harassment. So harassment is typically considered repetitive behavior, and yet a one-time incident that is so significant that it has lasting influences can also be considered harassment. So harassment occurs when someone makes unwelcome remarks or jokes about your race, religion, sex, age, disability, or any other grounds of discrimination. Now, I want to be clear about this. Harassment under the Human Rights Act or Code pretty much has to infringe upon one of the 11 areas of prohibited grounds. And I noticed there that there's not 11 things mentioned, but if it's any one of the 11 grounds for that are prohibited grounds, and it's a repetitive behavior, it would be considered harassment. And also, there are other forms of harassment under other legislation that might that would also be considered harassment under the other forms of other types of legislation. So workplace violence and harassment protection legislation under the Workplace Health and Safety Act is also considered harassment and a violation of that law. And if the harassment is based upon any of the prohibited grounds, it's a violation of both laws. If the harassment threatens or intimidates you, if it makes if it includes unwelcome physical contact, such as touching, patting, pinching, or punching, can also be considered an assault above and beyond harassment, which is a violation of another law, not only human rights law. Where can harassment occur? Harassment can occur anywhere, any place, anytime. It does not have to happen in the workplace. It has to happen between two workplace employees, and most often would occur and rise to the form of a complaint when it's between a superior and a subordinate, but doesn't have to be between a superior and a subordinate. It can be both upscale or across in terms of seniority. Is there a time limit with respect to a complaint for harassment? Under the Human Rights Code, a complaint of harassment must be filed within 12 months of the last event of the alleged harassment. So what that means is if a person feels as though they're being, let's say, for example, sexually harassed and that there's inappropriate comments, touching, or something that rises to the level of harassment under the Human Rights Act, and if it happens over a persistent period of time, and even if there's a break of 1 year, and it starts again, as soon as that harassment occurs, then it automatically includes everything that happened prior to it. So it's important that, and this becomes an issue all the time, and it's contested in courts over the 12-month clause, because some people feel so intimidated in certain forms of harassment that they don't complain about it within a 12-month period. And then it comes up later on in their relationship or in life or in circumstances. And so, for example, let's say, for example, 3 people are harassed by their supervisor at work, and they all quit, leave the company, move to a different department, or do something to make it stop. And then 4 years later, there's another harassment involving another person, and it becomes media worthy, or it becomes known throughout the company. And then the other previous 3 people come forward. Their complaints no longer rise, the 3 people from prior no longer have a valid complaint under the Human Rights Act to make their complaint go through the process. The current complaint does, because it's within 12 weeks. It doesn't mean that they can't bring those previous people together as a witness. It just means they can't rise their own complaint. Now, the statute of limitation with respect to civil litigation, to sue somebody, or to, under criminal litigation, to have criminal charges against somebody, have longer terms. But I think that the notion with respect to this time limit is to encourage people to make the complaint in a timely manner, because we want it to stop. We want it to go away. We want the problem to be fixed. We want it to be dealt with. If there's penalties, we want the penalties to happen now. We don't want it to become so bad that something really, really even worse happens. Bad things are already happening. We don't want something worse where people lose their job or commit suicide or have lasting emotional turmoil or effect on their personal lives. So the people complain about politically the 12-month limitation because they say that people who are sometimes are so intimidated they can't rise to have the courage to make the complaint. But this really has got good intentions, doesn't necessarily always have good outcomes. The multiple choice questions. Identify and select the answers below that does not constitute harassment. Okay. Discrediting the person by spreading malicious gossip or rumors, ridiculing him or her, humiliating him or her, calling him into question. Well, I would say that's got to be harassment. A single or isolated incident, such as an inappropriate remark or having an abrupt manner, that is not considered to be harassment. That's rude, it's inappropriate, it's bad, it probably doesn't help with employee retention or employee relations. But if it's a single or isolated incident, it could be a violation of human rights, but it's not a violation of human rights harassment if it's a single or just an abrupt manner, unless, of course, that single incident was so significant that it had long-lasting effect, that they proved that the single incident was worthy of being treated as harassment. C, an unwanted sexual advances which may or may not be accompanied by threats or explicit or implicit promises. Well, of course, that would be harassment. Making rude or degrading or offensive remarks, that would be considered harassment. Friendly gestures among coworkers, such as a pat on the back, that is not necessarily considered harassment. If there is a complaint, and if a person says, that makes me feel this way, and people become made aware of the fact that pat on the back makes them feel that way, but people intentionally, knowingly continue that, then it could rise to the level of harassment. But if someone just said, hey, Joe patted me on the back, that's harassment, that would not rise to the level of the definition of harassment. Isolating the person to no longer talking to him or her, denying or ignoring his or her presence, distancing him or her from others, that would be considered harassment. So both B and E are issues that sometimes usually would not be considered harassment. So we've heard the term quid pro quo. Oh, by the way, we are 2:30. We've got 15, 20 more minutes. We're going to take a break for 10 minutes. Quid pro quo is another Latin expression. Very often we use Latin expressions in things like human rights and in employment law because these decisions and laws are made often with the use of the courts. And of course, the courts use a lot of these expressions. So it means the almost literal definition of the translation of quid pro quo means this for that. So when quid pro quo is very often, more often than not, used in the examples of sexual harassment. And so, a person would say, the supervisor offered to give so-and-so a promotion in exchange for this sexual demand or relationship or something. But quid pro quo stands by itself means this for that. So it could mean that you offered something in exchange for something else. So very often, it's used in exchange for testimony. You're going to give me this testimony in exchange for not being charged, or you're going to give us this term in our contract in exchange for that increase in the price. So quid pro quo can be used in a lot of ways, but when it's used in the form of harassment, it's usually about sexual harassment or some form of discrimination. So it occurs in the workplace when a manager or other authority figure can hint at, you can only merely hint at that he or she will give the employee some special consideration, a raise or a promotion or something else, a new desk, place of work, better hours, and for the employee's satisfaction of some form of sexual demand or relationship demand. Changing work standards after an employee consistently refuses repeated requests for a date. So asking a person out, and they say, asking a person out on a date, by the way, is a violation of most, I'm sure, most companies' human resources policies, but it's not necessarily considered harassment or a violation of human rights law, unless, of course, it becomes associated with some sort of punishment or reward. So if the person asks another person out on a date and punishes them for saying no or rewards them for saying yes, then that would be considered a violation of human rights. Disciplining or firing a subordinate who ends up in a romance. Well, I think it's probably who ends up in a romance that ended. So that would be considered harassment or a violation of. So the romance in itself is not necessarily a violation of human rights. Hey, all kinds of people met at work in their life or at school or in some place of business as a supplier and a buyer or something. So a romance in itself is not a violation of human rights. An unwanted attempt at romance and then using some policy at work is a violation of human rights, and that would be considered quid pro quo. A job applicant also may be the subject of some kind of harassment if the hiring decision was based upon the acceptance or rejection of some sort of sexual advancements or some kind of inappropriate behavior. So, in summary, the Human Rights Act in itself states it is the principle that all individuals in Canada should have equal opportunity to make for themselves the lives they are able and wish to have, and to have their needs accommodated. And the act is meant to promote this equality in the statement above by prohibiting any discriminatory practices based upon specific attributes such as the 11 prohibited grounds, including race, ethnicity, or sex, and the other 8 grounds, which may hinder the prevention of the person from doing so. So making the lives they are able to and wish to have should not be infringed upon and should be accommodated when it comes to the issues of prohibited grounds. So human rights legislation is often combined with the principles of diversity, equity, employment equity, and inclusion. It's 216. I'm thinking that because we're kind of moving into a new area and it's 216, we got 15 minutes for our next break. So let's take our 10-minute break now and come back at 2:25, and then we'll jump into the Employment Equity Act and we'll move forward from there. My goal, by the way, today, because we moved so quickly through the early section, because it was redundant or repetitive over some of the things that we did yesterday, and we're almost exactly the same group as yesterday, is to get you done just shortly before 4 o'clock today. So what we're going to do is I'm going to put my screen on freeze, and I'm going to ask you guys to make sure that you put your screens on freeze. Do not leave the session and try to rejoin. That can create some problems. I'll see you back here in 10 minutes at 25 minutes after 2, and then we'll jump into the sections on diversity, equity, and employment equity for until about 3:45 this afternoon. Hello, everyone. Welcome back again. I hope didn't lose too many people during the break. Just want to take the opportunity before we get going again to allow anybody to, you always are allowed to, but jump in, ask any questions about what we've covered so far. If not, I will just storm along. Okay, so the next part of it is really probably more appropriate for two kinds of companies, staffing companies, or that are involved in two types of activities. The first is if you are involved in providing services to the federal government, temporary help or otherwise to the federal government, and or if you are significantly involved in the recruitment of or placement of people in federally regulated industries. So I'm going to give you an example. I once had a contract with a large company that imported equipment that was used for medical and food handling types of stuff. And they were legislated under the Federal Food and Drug Administration Act. And so they were required to have an employment equity program because employment equity legislation in Canada is federal, it is not provincial. And since we were a provincially regulated company doing work for a federally regulated company, they required us to do to participate in their employment equity program. It was a condition of the contract. And if you are a supplier of temporary staffing services to the federal government under the various vehicles that they have to supply temporary help or other services, if you supply more than, I believe the number is $300,000 a year to the federal government, then you are required to participate in what they call the Contractors Employment Equity Program, which imposes federal legislation on provincially regulated companies who are doing business with the federal government. And it's particularly applicable to temporary help because the federal government's got this employment equity program for all their employees, but they've got a significant portion of their workforce comes from third-party suppliers. So they want to make sure that everybody is on the same page. So employment equity legislation in Canada is very specific. There's generic terms, employment equity. You'll hear a lot of American news and issues where they talk about employment equity. It's not the same thing legally. Addressing the same kind of big picture issues, but not the same thing legally. Employment Equity Act is federal legislation in Canada, applies to the federally regulated companies, and there's this employment equity program for contractors for the federal government. This is to deal with 4 designated groups: women, people with disabilities, Aboriginal people, and visible minority. The Employment Equity Act states that employment equity means more than treating people the same way, but also requires special measures to the accommodation of differences. And what it really is all about, sorry, I got to get my computer clicking through here. What it's really all about is statistics. The Employment Equity Act federally is designed for organizations, federal organizations, regulated organizations, to know what the distribution of the various groups are in the societies that they act in, what percentage of the population are people with disabilities, what percentage are women, what percentage are Aboriginal people and people with visible, self-identified visible minorities, and that it is intended to encourage policies in companies to help move towards a workforce that accurately reflects the same distribution in the company as in the community. It is not quotas. It does not specifically say that you have to give priority to certain kinds of workers. It is not quote unquote reverse discrimination. It's saying know what the distribution is in your community and know what the distribution is in your workforce. And if they're not the same, try to figure out why. And if you've got policies that can help to improve it so that your company more accurately reflects the community, then implement those policies. So it is, I'm going to read more specifically, though that was in my own words, but I'm going to read more specifically. It says that they want to achieve equality in the workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to their ability, and to correct the conditions of disadvantage in employment experienced by women, Aboriginal peoples or persons with disabilities, and members of visible minority groups by giving effect to the principles that employment equity means more than treating persons in the same way, but also requires some special measures to accommodate the differences. So they're saying, yeah, we want to treat all people equally. That's the fair thing to do. That's the right thing to do. That's the thing to do under human rights standards. But with respect to employment equity, if there is inequities that exist because of some existing or pre-existing conditions in the workforce, in the workplace, let's see what we can do to fix that. And to expedite it, you might need to do some extra little things. It doesn't mean when you've got two candidates, you have to give priority over one candidate or the other. But it means that if you haven't been advertising in a particular place, or you haven't had the right kind of food in your cafeteria, or if you haven't had the right policies in place, fix those things so that we can start to see the workforce more accurately reflect the distribution of these people, of these groups that's in the community. So the provincially regulated suppliers program, the federal contractors program, there's a link there. I know that you can't link on my links, but in your printout, the link is typed out for you, or you can just type in provincially regulated suppliers for the federal contractors program for the federal government, and you'll find what's there. And the screen looks something like this, and it welcomes provincially regulated companies to learn how to engage in the program. So the program does this. Step one, employers are required to conduct a workplace analysis. That's collect the data. How many people in each of these groups, what percentage of our workforce do we employ? Conduct an employment systems review. So that's to take a look at your hiring policies, practices inside your company, and everything else from uniforms to cafeteria policies to vacation policies, you name it. Take a look at what goes on in the systems within your company. Then set out to develop an employment equity plan that deals with the inequities that are found from the analysis and from the systems that you've identified, and establish and sustain an employment equity program. So now you have to give it the resources to keep it in place, and then submit a report once a year to the federal government to show them that you are doing it. They don't measure you on results. They don't measure you on each individual specific aspect of the plan, but they want to know, did you do an analysis? Have you reviewed your systems? Did you develop a plan? Are you implementing the plan? And are you reporting and monitoring the outcomes of the plan? So employment equity involves all of the following, except one is not like the other. Identification of systemic barriers to employment opportunities that adversely affect designated groups of members. Yes, it does include that. Government imposed quotas. No, it does not include any form of quotas whatsoever. Plans to overcome employment barriers. Yes, that's part of the systemic review. Reasonable accommodations. Yes, that's part of the systemic review. Be proactive in planning an annual employment equity plan. Yeah, we're required to have a plan. So, if we were live and having a chat, we'd want to talk about some things like baby boomers approaching retirement age and the shortage of young people in the workplace and how these issues are affecting our decisions. Are our baby boomers stuck in am I stuck in my ways, doing things the way I've always done them, and not approaching a more diverse workforce because maybe I'm a boomer and I don't get it? Or am I staying in the workplace too long and not making too long? There's no such thing as too long. Am I staying in the workplace longer than probably expected than age 65 and not making room for younger people? Are we promoting people of certain genders and backgrounds in jobs? So normally, if we were in the room, we'd have a pretty good conversation about what's happening in society. We've got another program called the AODA, the
Steve, could I chime in? Are we supposed to be on a different slide other than the Employee Equity Act?
See, there you go. I didn't unfreeze the screen. Thank you.
Thought it was just me.
Yeah, no, thank you. So I'm going to figure out how to do that. My screen is, your screen sharing is paused. Okay, so I'm going to just show you what those screens look like. There's not a whole bunch on there, but yeah, you're right. This is where we talked about the federal contractors program with the link. You'll find that in your written document. Thank you for jumping in. This is what the screen will look like if you go to the federal government employment equity program. If you want to enroll in it, if you're a federal government contractor, this is what the screen will look like. These are the 5 steps that I talked to you about with conducting a workforce analysis, conducting an employment system review, creating a plan, implementing the plan, and doing your reports. There's our 5 questions where the answer is government imposed quotas. We do not have government imposed quotas in employment equity plan. And there's where we would have our chat. So thank you very much. We're now all caught up on our screens. And in Ontario, we have a thing called the Accessibility for Ontarios with Disability Act. Other provinces have similar programs. This one was introduced more than 10 years ago with a long, I think it was 2010 that they introduced this particular program with a long list of 2025 before it reached all of its milestones. And the act was designed to give people a timeline for when they need to achieve certain things. And it broke the marketplace down into municipalities and government organizations and private organizations. So it speaks to developing and implementing and enforcing accessibility standards in order to achieve a better standard for Ontarians with disabilities with respect to goods, services, facilities, accommodations, employment, buildings, structures, and so on. And so we're reaching the end of the AODA. Most of us and most municipalities and government act together. So companies are supposed to have a customer service plan and have some training for all of their employees on how to deal with people with disabilities, on how to accommodate them, how to approach them, what kind of services are available, and so on. That was the first step of the plan. Well, it was 2005, so it was like 20 years ago. The second part was for organizations to implement information and communication standards. So things like making your website accessible for people with disabilities and creating documents inside your organization that maybe have got Braille or larger print or available in ways that can be read using text-to-voice technology or something. The third was to implement employment programs to create greater diversity for people with disabilities. The big one that we've all noticed the most is, I think, transportation. You now see buses in Ontario and trains for people with disabilities. You know, I don't mind telling you this. I have a 29-year-old daughter, extremely disabled, wonderful Samantha, wonderful, beautiful person. She can't read, she can't write, she can't speak. She's in a wheelchair, she can't walk. She has very limited physical dexterity. She is a kind, generous, thoughtful person who understands music and friends and love. And she never forgets people. And she never forgets, if you had to play Name That Tune, she can't name anything, but she knows every song. She recognizes every song in the first 3 notes. And so, you know, her brain kind of works, but it doesn't work the way you would expect someone to working in the workforce, because she can't perform functions at work. And so we're pretty in touch with transportation. And, you know, we went to we went to a Ed Sheeran concert recently, and we took the train. And we don't usually take the train. We've got a wheelchair van. And man, I was blown away by the way that the Go Transit system is specifically designed to have special platforms for people in wheelchairs, and they've got special spaces for people in wheelchairs and special waiting areas and people there to accommodate the wheelchairs to get on and safely get locked down on the trains. And the same goes for buses now that have got leaner buses where they lean down closer to the ground, and out come these ramps to allow wheelchairs and people with walkers and people with disabilities to get on and off the buses, and special wheelchair spots. So we've really noticed a lot with respect to transportation. And we've all noticed also the built environment with respect to elevators and escalators and lifts and opportunities for people to get into theaters and stores and retail spaces and push buttons on the doors. And so we recognize all these things. And for some people who've got family members with disabilities, we are really aware of the fact that when they don't work and when they're not present. And of course, there's some exemptions for buildings that are built before a certain time, and for heritage buildings that they don't want to destroy their heritage look and appearance by knocking down walls and putting in elevators and things. So there are certain places where it becomes very apparent to us. But we're now to that final stage, 25, 20, now we're 23 years later, in terms of, or 18, 10, 20, 18 years, 20 years later, in terms of the built environment. And we all have an obligation to be aware of what we need to do with respect to customer service, information, communications, and accessibility. So just on that topic, I mean, 1 in 7 Ontarians is self-identified to have a disability. And I think the answer is higher than that, because disabilities include hearing impairments and visual impairments and physical disabilities and allergies and, you name it. So 1 in 7, I think, in terms of working people, and a much higher number in terms of the entire population. 25% of the disability, 95% of the disabilities are hidden or not immediately visible. So people, if they want to be accommodated, need to self-identify. It's estimated that 1 in 5 Canadians will be 65 or older by 2025, and half of that group will have some form of disability. Half of the aging group will have some form of disability. And that water fountain discussion that we could have had earlier about an aging population remaining at work. If half the people who work for us who are 65 or older have some form of disability, and people are working longer and later in life, then we got to try to figure out, how do we make these accommodations at work? More than 500,000 Canadian now will have some form of vision loss that is not corrected by glasses. And more than 1 million live with some form of hearing loss. And we've got to ask ourselves the question, do our telephones and do our iPhones and do our work phones and do our work computers all accommodate people with these times of, and let's not even go down the road, we should go down the road, about people with mental illnesses. Now, mental illnesses cover everything from stress responses to those diagnosed things, manic depression, schizophrenia, other stress-related mental health illnesses. Think about all of the, about substance abuse, alcohol abuse. Think about all the various forms that mental health illnesses can fall into, including in our aging population, dementia and Alzheimer's. I own a home care company, and like 95% of our clients or patients that we deal with have some form of dementia or Alzheimer's, or just natural aging illnesses that affect their memory and their ability to make cognitive decisions. This is affecting us in our workplace. It affects us in our recruitment. It affects us in our retention, how we serve our customers, how we operate, how we work with our suppliers and our customers. So if you get anything out of this, come away from this particular session asking yourself, am I aware? Do I pay attention? Does it matter? And how can I make a difference? So what's considered to be a disability? There's physical disabilities, infirmities, malformations, and disfigurations, mental impairments and developmental disabilities, learning disabilities, mental disorders, injuries, And injuries can include things like allergies, to dust, to smells, to things in the workplace. Disabilities may be continuous, they may be intermittent, they may come and go, they may be temporary, they may be severe, they may be unrecognizable. So, think about, and I also always want to remind people when we're going through this part of the session that when we're dealing with people with disabilities, whether a job applicant, a current employee, a customer, a person that we might be considering to place with one of our customers, and sometimes their behaviors or their actions aren't exactly within the norm of what we expect in society for our average worker. We ask ourselves sometimes, do we get annoyed by that behavior? Do we get annoyed by a person who constantly asks us to repeat something, or who forgets something, or who needs to be accommodated because they have to come in at a different time of work or have a different equipment at work? Does it ever get under our skin? And the answer is, yeah, it does. And it shouldn't. Because every time we deal with a person with some form of disability, with some kind of difference, even let's now go out of the AODA concept and ask ourselves, is it some form of difference that comes from age or from sex or from sexual orientation or from place of origin or religion? Does it get under our skin because they behave in a way that's different from me, from us, from you? And the answer is, yeah, it probably does. And we need to always take a step back. And we need to say to ourselves, what if it was obvious? What if this disability was obvious? What if this person, let's say, for example, if a person has cancer and they have greater needs, do we get upset with them? Do we need to go cut their grass or make their food? No, we don't do that. When it's obvious and it's visible, we tend to be subconsciously more accommodating, more forgiving, more thoughtful, more considerate. And when it's not visible, we tend to be more agitated and less forgiving. And we set a higher standard. And so every time that we are confronted with a situation where a person who doesn't show up for work on time, or maybe lets you down, before you jump to conclusions and fire somebody or never accommodate them or never consider them as an applicant, ask the question, is it possible that their child was sick that day? Is it possible that their mother took ill? Is it possible that they had some kind of physical disability or issue that affected their ability to get through the morning the way that you got through the morning? And having the patience and the demeanor to consider the fact that everything that we're confronted with is not always obvious makes us better people, makes us better employers, makes us better co-workers. It helps us to diversify our workforce in a way that we can now attract and retain the best workforce. That we now can have a workforce that is so diverse that maybe our employee understands our customer better because they've got something in common. Maybe we're able to provide a service in a different way because we accommodated something, because we accommodated an employee who now can accommodate a customer. We want to choose the best workers and have the most diverse workforce from the entire world, not from a single point. When we're able to hire people from everywhere, from every walk of life, from every place in the country, from every background, we have the potential of hiring the best people. And when we have unwittingly, unknowingly, systemic discrimination, because we're only recruiting in a particular place, or we're only hiring certain kinds of people, we may be eliminating the absolute best people that could work for our companies. So in order to achieve greatness, to expand our workforce, to attract better people, to relate to our customers, to provide a better service, we need to have these policies in place. So a simple AODA policy, so on the issue of just the issue of disability. Here's a sample of what a policy should look like, and we're all required to have a policy. The organization is committed to providing exceptional and accessible services to our customers. Our services will be provided in a manner that respects the dignity and independence of all customers. The provision of services to persons with disabilities will be integrated whenever possible. Persons with disabilities will be given an opportunity equal to that given to those of others to obtain, use, or benefit from our services provided by and on behalf of our organization. So that's what a simple sample AODA policy can look like. And we are required inside our companies to have this policy, to have a training policy, to use assistive devices and to accommodate animals and peoples and persons with disabilities. And we're supposed to have a way to provide notices of temporary disruption. So if our elevator breaks down, or if our voice to text to voice, software isn't functioning properly, we need to have ways of providing notices of disruption to people so that people with wheelchairs don't show up and people with other disabilities know how they're going to be accommodated in the near future. We need to have in our policy some feedback process so that our customers and our employees can tell us about their feedback and how their concerns are. And we have to have notice and format of availability of documents in all formats to be available to people with all forms of disability. So that's different from a DE and I, diversity, equity, and inclusion. You hear all different kinds of acronyms for this. Today, we're going to call it diversity, equity, inclusion. So diversity, equity, inclusion is not a legislation. It is not a law. It is not provincial or federal. It's a concept. Companies that are diverse, equitable, and inclusive are better able to respond to challenges, to win top talent, and to meet the needs of different customer bases. I remember back in as early as, I think about 1987, I ran a Toronto chapter access program with a gentleman who talked to us about why we should have DE&I in our workplace. And he talked about the importance of growing our businesses, and that we can, as our communities become more diverse with more immigration, that we cannot grow our companies unless our workforce can relate to our customers. And if 25% of our customers or 50% of our customers are going to become recent immigrants or first or second generation immigrants to Canada, why can't our workforce, and why wouldn't our workforce reflect the same diversity? If we want to grow by 50% to accommodate though and have those people, new immigrants and first and second generation immigrants, to be our customers, doesn't it only make sense that the people who work in our company would be the same? So it isn't just because it's the right thing to do, or a good thing to do, or a heartwarming thing to do, or a legal thing to do. It's something that we should be doing for the success of our organization, for the success of our business. So when we talk about diversity, we talk about gender diversity and age diversity and ethnic diversity and physical ability and neurodiversity. When we talk about, mental health illnesses and other cognitive disabilities. Now, equity is another word that is used, and it's used, like, for example, it's used in the term of the federal government employment equity program. But equity is a concept, it's not a law. And equity refers to the fair treatment of people so that the norms, practices, and policies in place ensure identity is not predictive of opportunity for workplace outcomes. So in other words, that if we have equity, then people that are very different can somehow achieve very similar outcomes. Equity differs from equality in a subtle but important way. Equality assumes that all people should be treated the same. And equity takes into consideration a person's unique circumstances, adjusting the treatment to that person so that the outcome can be similar or equal. So we treat people equally is good. But treating people equally isn't always good enough because all people are not the same. But treating people with equity means that we've got subtle differences in the way that we treat them so that they have the opportunity to have the same outcomes. Inclusion is not a law, it's a concept. And inclusion refers to how the workforce experiences the workplace and the degree to which organizations embrace all employees, enable them to make meaningful contributions. So when we talk about inclusion, we think about listening and understanding and not making unilateral decisions about what we think is best for everyone when we probably don't know what is best for everyone. Companies that are intent on recruiting a diverse workplace must also strive to develop a sufficiently inclusive culture such that all employees feel that their voices will be heard. Voices that are critical if organizations want to retain their talent and unlock the power of their diverse workforce. Now, I'll tell you that good policies, practices, systems, training, information, technology, these make good companies. Extraordinary companies do extraordinary things. And extraordinary companies figure out how to include everyone so that each individual's special, unique talents, experiences, and knowledge can be brought to the forefront and somehow integrated in a way that can help a good organization become great. So DEI and equity for all is things like human rights legislation that we talked about today, employment standards legislation that we talked about yesterday, employment equity legislation like the federal legislation that we referred to today, the AODA legislation that's unique in Ontario, but other similar legislation and regulations exist in different provinces and municipalities. So DEI and equity for all means greatness for companies. The final part of our session today is going to be on privacy. Let's take a look at our time. We are 3 o'clock. We're going to try to be finished in about 45 minutes or less. So privacy legislation has been around for a long time. It kind of flowed out of the Charter of Rights and Freedoms because there becomes this conflict about if you've got rights to privacy. If you've got freedoms to information. So how do you combine together freedom of information to privacy and still meet all of the standards that we want to uphold in our country? And so we first focus on the privacy of information, and the PIPEDA stands for Personal Information Protection and Electronic Data Act. And it became part of our legislative and statute world, mostly because of the growth of the internet and the opportunity for electronic storage of data. We know that things get leaked and things are available and people get breach passwords and all kinds of bad things can happen when we don't protect our data properly. So personal information protection and privacy protection is to protect the personal information in the hands of private sector organizations and accompanies this with guidelines for the collection, use, disclosure of that information through the course of commercial activities. PIPEDA applies to private sector organizations across Canada that collect, use, or disclose personal information in the course of commercial activities. The law defines a commercial activity as any particular transaction, act, or conduct, or any regular course of conduct of a commercial character, including the collection, the bartering or leasing or donors, fundraising lists, all kinds of lists. It's federal legislation that affects federally regulated companies and organizations, including the federal government, federally regulated industries, and those companies that fall under that jurisdiction. The provinces were given the opportunity to onboard. And the provinces could decide if they were going to introduce their own PPIDA acts, or whether they were going to just simply adopt the federal act, or whether or not they were going to reject it entirely. So Alberta, British Columbia, and Quebec have their own private sector privacy laws. So the PPIDA, and they probably refer to it as PPIDA, but they have laws that are almost exactly the same as the federal laws. Now, the government could have said, yeah, let's just abide by the federal laws, but provinces don't do that. So they literally cut and paste and then change some of the terminology to apply to their provinces. Organizations subject to substantially similar provincial policy laws are generally exempt from provincial laws. So if for some reason an organization has to apply by the provincial law, they don't have to apply by both. They just apply to the provincial one. Now, Ontario, New Brunswick, and Nova Scotia, Newfoundland, and Labrador, they've adopted substantially similar regulations regarding the collection, use, and disclosure of information, but they've limited it to personal health information. So they didn't say in Ontario, every employment agency has to abide by these laws. But if the information you're collecting have something to do with health information, so their benefits plan and their access to their benefits and their use of benefits, that would be health information. You would be required to protect that information. But their employment information, like their resume, you should protect their privacy of their information. But we only have legislation and you probably could get sued civilly if you let go their private information, and particularly if you did it over the internet, which is federally regulated, there's going to be some issues. But you don't specifically have to apply to any information except for the highlighted blue things below. For example, in the province of Ontario, there is the Information and Privacy Commissioner of Ontario. So they went the other way, as the federal government has too, and they said, what is the information that we must disclose? So the Information and Privacy Commissioner of Ontario talks about what they must disclose and what they must withhold in provincial government organizations. The Freedom of Information and Protection of Privacy Act deals with federal or provincial government and what information they must disclose. So, for example, if you want to find out how much somebody makes in the provincial government, they've got the Sunshine List that they produce. So they tell us how much money people make. That's freedom of information laws. But if you want to find out about more specific information about their health and privacy and other things, then it's protected. So the government must protect this information, but not necessarily you. And then they introduced the Municipal Freedom of Information and Protection of Privacy Act, which then said, now municipal governments like the cities and towns have to abide by the same rules. And then they introduced FIPA, the Information Concerning Health Information. Sorry, I've just clicked on the wrong button here. Sorry, my apologies. And so then they introduced the information concerning health privacy information. And so, for example, in my, I own a home care company, and we're collecting personal health privacy information all the time. So we have to apply by that legislation, which is kind of interesting. We don't have to apply by the legislation with respect to our employees, although we do protect their information, but our clients, super protections in place and abiding by all of the laws. So the 10 principles of PPIDA. So you have to yourself, if you don't have to abide by PPIDA because you're provincially legislated and your province hasn't implemented specific legislation that covers you, although many provinces have, it's really important that you abide by the same principles anyways. First off is accountability. You got to be accountable to take responsibility for the protection of it. You have to identify the purpose of which you collect the information. So you have to tell people, I'm asking you for this information because, and it's only going to be used for this purpose and not for any other purpose. And then we have to get consent from people. That's why you're always asked on the phone, particularly when they're asking you about some health information or your health card number or something. They make you fill out a form or sign a consent form or give consent at the school for your kids for things, because consent must be given before they can collect and keep and store that information. And then they have to tell you what they're going to limit the collection to. So they have to tell you what they're going to use it for, and they have to promise and implement policies that they're limiting the use of that information to the collection of that information, and only, number 5, limiting the use to that specific purpose. Organizations have got an obligation under PPIDA to make sure that the information they retain is accurate. So if it's updated, they got to update it in their systems. They need to provide safeguards and tell people about what the safeguards they have in place in order to protect that information. The legislation requires you to be open. That's why you hear in the news all the time about websites that have been breached and companies that have been hacked, because they've got an obligation to tell people, hey, your information might be at risk. So if you ever had information at a bank, which is federally regulated, which of course wants to protect your information because they're a bank, but they're under the federal legislation, have to protect your information under PPIDA legislation, and because they don't want your money stolen. So if there's ever a breach at the bank where someone might have got access to credit card information or document files, or there's been somebody, they've got an obligation to tell you about it. And then they have to give you access to your information so that you can see what information they hold. And there has to be a process in your policy that people can challenge your compliance with these laws. So they need to be accountable for what they do. They need to identify why they're collecting information. They need to get your consent to collect that information. They have to limit the collection of the information to only the purposes of which it was intended. They have to limit the use of that information for only the purpose of which it was intended. They have to ensure that it was accurate. They have to provide safeguards to ensure that it's protected. They have to be open with you about what's happened in terms of those safeguards and your information. They have to give you access to your information so that you can dispute it or change it or lock it or freeze it or update it. And they have to give you an opportunity to challenge their compliance with the legislation if they're not. So what would be considered personal information under PPIDA? Age, name, identification numbers like SIN numbers, health card numbers, your blood type, your religion, your opinions, your evaluations, your comments, your social status, your employee files, your credit records, your loan records, your medical records, the disputes or things that you've had with your employer in the past. Now, federal government employees with their employees in the past. And any things like training, extensions, job transfers, those should all be covered under PPIDA legislation. If your province has adopted another privacy legislation, therefore PPIDA does not apply to you. Your province has adopted other privacy legislation, and therefore your PPIDA does not apply to you. The answer is true. The federal PPIDA does not apply to you. But whatever your province has put in place may apply to you. In some provinces, most provinces, it applies to provincially regulated private organizations with a certain number of employees or a certain amount of revenue. In some provinces like Ontario, it only applies to provincially operated, like the government, municipalities, education, school boards, and health records. Health records, even if it's a private company. But all the other stuff, not if it's a private company. Which of these following statements about PPIDA and consent is false? Organizations can generally rely upon implied consent when the information is likely to be considered sensitive. The answer is no. An organization cannot say, by reading this thing, you've implied consent, or by receiving this email, you've applied consent, or by buying this widget, you've implied consent. They have to ask the question, do you consent? So the consent mechanism that you choose must be clear and unambiguous by saying, do you offer your consent? But the consent can be offered in many different ways. It can be done in person. It can be done by phone. It can be done by the internet. It can be done by clicking a button. It can be done in a whole bunch of ways, but they have to be clear and unambiguous, saying, do you offer your consent for us to collect and use this information for the purpose of which it was intended for? They cannot say, when you buy this thing, you've provided consent. Or, so what's a good example? I think Rogers or Bell or somebody basically, in the beginning said, as a customer, we promise to do this stuff. And if you continue to do business with us, you've implied consent. If you don't cancel your contract, you've implied consent. That went to court and got knocked down in 2 seconds flat, because that they couldn't say, oh, there's a new law. But if you don't cancel your contract, you've implied consent. They had to go to everybody and get them to click on a button. And so some people, they gave them a long time to do it. But anyways, so the process with respect to PIPEDA is pretty simple. We make a complaint. You make a complaint to your organization. You go to the privacy, your organization, and it escalates to the privacy officer in your company. It's kept private with the privacy officer in your company. You try to get some agreement on what they might be done for them to be in compliance. And if you've gone through a process of complaining to your company, your organization, or your government about your privacy being breached, then you can go to the privacy commissioner and you make a complaint to the privacy commissioner, who then goes to the privacy officer of the company and tries to resolve it with early resolution. And if not, it'll end up in court. So we've got some issues. We're not going to go way down this rabbit hole with respect to privacy and social media. But keep in mind that things like COVID-19 really infringed upon our individual privacies, that we had to show that we'd been vaccinated and that we had an exemption, and we had to prove that we'd done certain things, and we had to prove that we weren't sick. Those were some things where, in the bigger picture, courts decided that it was in the best interest of society to overrule individual private privacy issues. And then we've got issues of social media, Facebook, Twitter, Insta, LinkedIn, all of the social media platforms, where most companies have got Google accounts, and they've got Google Maps accounts, and they've got Facebook company accounts and LinkedIn company accounts. And then employees become linked to those company accounts. And then each of us has our Facebook accounts, and we belong to groups, and some of those groups are of industry things and business things. And, I don't need to tell you how social media works. But the question is, what's the deal? What are companies allowed to tell us to do and not to do? And what are we supposed to do and to protect our privacy? And, the answer to the question is, oh my goodness, the answer to the question is that we need to have a company policy. And that company policy should reflect personal privacy. And it should also reflect the needs of the company. So they can do things like using what we talked about yesterday, the Electronic Surveillance Act. We need to tell people what we know about you. We see you walking down the hall. We know when you're online. We know when you log in. You're using company email. We have the right to read your email. We have the right to download and save and keep your email. Your email might be about critical customer and employee interactions and policies and programs. And if you quit, die, get fired, or retire, we're going to have to go into that email to look at it. We might have a policy that says we won't arbitrarily go into your email, but in any circumstance, we have the right to do that because you may not be around to give it to us, or we might think you're truthful or honest, or you might have stolen from us. Companies need to have policies with respect to their and declare what their policies are with respect to electronic surveillance. Notwithstanding that, they can also have policies with respect to the use of the tools and technology. companies can tell you you shouldn't go on social media. You're not allowed to go on social media. You can't use the device that we provided to you or the internet that we're paying for at the office to go onto social media. But if you're a good recruitment company, you probably are pretty active on social media. And you're probably encouraging your employees to be on social media, to post their jobs and to search for candidates and to join groups. And so as we look at these things, we got to ask ourselves, do we want to encourage people to do stuff? Or do we want to stop people from doing stuff? And if we want to stop people from doing certain things, but we want to encourage them to do other things. And the only way around this is to, number one, respect people's personal privacy. Number two, to understand human rights and to not ever really get involved in opinions and or policies that are going to affect a person's human rights. We want to treat people with dignity and respect and equality and inclusion. But we also need to be very clear what's allowed and what's not allowed. Comments about your customers, your employees, your coworkers, your products, your services may not be allowed on social media. Making disparaging remarks about people or making political opinions that could unintentionally be associated to the company. That you might be able to have, for example, one of my daughters is a teacher and her social media accounts don't say her full name because she uses Twitter and Google Classroom and all that other kind of stuff in order to interact with her children or students and their parents. But she doesn't identify by putting her picture or personal information or even her name on Facebook or Insta. And she doesn't accept friends from anyone except for in that small social group. So having policies and practices and recommendations and training that affect people's behavior in social media is really important. You can go wrong. You can make mistakes. You can overlook things and not have a good enough policy. You can have a policy that's overzealous that upsets your employees. You can have a policy that's overzealous and doesn't allow you to benefit from all of the benefits that social media and the internet have to offer. It's your responsibility. As an employee, it's your responsibility to act responsibly. To understand that if you start posting things on the internet that are offensive to even a small percentage of the population, that they might consider, and if your social media accounts are somehow related to, associated to, or even make reference to your job, that could be cause for termination. So, and these things will get fought in courts from now to the end of the world, and it will become increasingly more clear on issues that have been decided in the past, and increasingly unclear as technology advances and the opportunity for us to be out there in a whole variety of places changes and evolves. So I'm willing to answer any questions from you with respect to social media, but I think for today, we have zoomed through, this really quickly today. Hopefully I didn't underserve you by going too quickly on some of the topics, but I'm going to leave the floor open now for people to ask questions. I'm just scrolling back through the screen because I see if there's anything I want to intentionally spend more time on, but I think we got it covered. So from the floor, questions from people, comments?
I have a question. Do you know when we would have access to register for the sales module?
That is me. I took on the responsibility to do that. I'm in an editing format now.
Okay.
We took a 17-hour sales program, tried to knock it down to 3. That's virtually impossible. So now I'm in the stages of trying to figure out what is not so important. Maybe we'll put it into 2 or 3 modules, step 1, 2, and 3. It will be optional, and it will be available for you in the fall. Okay.
And then because it's optional, I'm just assuming that there wouldn't be any sales questions within the exam if we don't attend.
No, if it's going to be optional. You're come the fall if you haven't taken. I don't want to encourage you to do this. Okay, I want to encourage you to take the recruitment.
I do want to, so I'm just
Yeah.
curious.
Yeah. So for people in the future, they'll have a choice between recruitment and sales in order to meet their minimum, and you'll always have the choice to take the extra one. So in your case, I would suggest that, and people on the phone today, take the recruitment one now, take your exam, get it done. And when the sales one comes available in the fall, take the option to take that course also.
Perfect. Thank you.
Okay. Any other questions?
Steve, quick question. Where sales and cold calling intersects with privacy or harassment laws, will that be covered in the sales module, or could I ask a question now about it? Or
No, yeah, go ahead and ask the question. And no, we're not going to get into privacy issues on the sales module. And we are going to try to give you some really good ideas about how to be more effective in cold calls, which hopefully doesn't make you harassing. But, you know, if you do it in some particular ways, but some people are always going to consider a cold call harassment. But anyway, it's your question. Sure.
okay, so even where it involves recruitment, we've had a complaint from, those people who are waking up in the morning looking for a reason to sue someone. Every once in a while, we recruiters encounter those types. So there was an individual who just didn't like getting an email because the job didn't match exactly what his expectations were, and accused us of not following privacy laws. I actually retained a privacy lawyer at that point to sort of see if we were in the right or the wrong. And I don't think we were completely in the wrong, but it was a bit of a gray area because he said, why don't we have a button saying unsubscribe? And I said, we've spoken before. You've given us permission to stay in touch with you. It's not a subscription per se, but anyway, it became this very complicated issue for us and scared a lot of my staff, a lot of my recruiters on staff.
Right. Well, sorry, there's something, stop share. I'm going to stop sharing that. Well, first off, privacy legislation with respect to employment applications in Ontario probably isn't really covered under PPIDA legislation, but you probably could be sued civilly for violating their privacy. Getting permission to email people is covered under the legislation, but if they click the button and gave you permission, then, you're not in violation there. If you started emailing them for things that they didn't give permission for, that's an issue. But I'm not going to tell you, don't go get a lawyer. But with respect to that kind of thing, just ask people what they want and give it to them. Like if they say, I don't want any more, I told you I don't want this, say, okay, let's go into your file and let's configure it in such a way that you don't get what you don't want. And if you don't want to receive any emails from us in the future, we'll, remove you from our database so you don't receive job postings in the future. That's usually the best solution. Some people listen, I get really angry at people that phone me on my home phone. I've had the same home phone number since 1984.
Wow.
3. Yeah. So you can imagine how many places my home phone number is listed with people that I don't want to dial me. And so, we get the clean your ducks and cut your grass and sell you credit cards. Like we get everything, right?
Right.
And sometimes I get annoyed and I'm rude, and sometimes I make fun of them, and sometimes it's funny and sometimes it's not, funny. It's funny to me, and then I realize how inappropriate I was, and making fun of them phoning me, and nobody likes to be bugged, right?
Mhm.
So there's a difference between bugging somebody, rubbing them the wrong way, and violating privacy legislation. And I would say for most recruiters in most circumstances in our industry, like 99% of the time, we're bugging them, but we're not violating the law. So, take that into consideration. And the best way to stop bugging people is stop bugging them.
Okay, thank you. I like that.
Yeah. We had a good question yesterday while the rest of you were trying to formulate your thoughts for a question. Last night, I received a question with respect to the information concerning the changes in legislation in Ontario concerning the determination of business consultants and IT contractors, and how it affects workers' compensation. And I gave an answer in an email. I didn't share it with everybody. But I looked a little bit more into it, and there's a couple more notices that have just come out that Access received like in the last 2 or 3 days. It might actually give us more clarity on it. But the answer to that question is this, that first off, with respect to business consultants and independent contractors, you can go to the ministry website, you can look it up. They give you definitions of the work that a person must be doing. The kind of work pretty much covers anything to do with business consulting and IT, but you got to look it up just to make sure. Secondly, they need to be separately incorporated or have a registered company. It can't just be named. They can't just say, oh, send a check to Steve Jones, but don't treat me as an employee. They have to have a business, and it has to be a registered business or incorporation. So that's fine. The third is that they got to make $60 an hour or more. The government basically said one of our tests is going to be how much you pay them. If you didn't pay them $60 an hour or more, they're probably not even a business consultant. They're just an employee that you're calling a business consultant, which I don't agree with, but that's the case. So you got to have a registered business. You have to have a contract that deems them to be a registered business and how they're going to get paid. They have to get paid by the hour, not by per diem or per month or per salary. They have to fit the definitions of a worker. And if that's the case, the question was, does that exempt us from paying workers' compensation? And the answer is, nothing's changed with respect to workers' compensation. There's several job classifications in Ontario where workers' compensation is optional. Don't ask me to explain this. I don't understand it. It's been this way since the beginning of time. But there are certain job classifications in industries in Ontario, like education, for example, that workers' compensation coverage is optional. Employment agencies are not optional. IT consulting is. So if the IT consultant is considered an independent contractor by the government, and the IT consultant has opted to not have their own workers' compensation, you may be exempt. But I'm not going to tell you on a call like this that all IT consultants are exempt. Each case needs to determine whether that IT consulting or business consulting is in an optional category. Each IT consultant needs to declare whether they're opting out or opting in. Otherwise, in the absence of it meeting the conditions of being an IT consultant by the government under the Employment Standards Act, meeting the conditions of being optional industry by the Workers' Compensation Board, then it's recommended that you either include them in your workers' compensation claims or get them to provide you with a clearance certificate that they got it themselves. I don't know why an IT consultant, especially if they had any employees whatsoever, would ever opt out of workers' compensation. It's so inexpensive. I can't even explain why they wouldn't pay the premiums. It doesn't make any sense to me, but they did it all the time. So the answer that I gave last night was ambiguous. The answer I'm giving you now is ambiguous. You got to look it up. But generally, just because the ministry said, okay, in January, they said, okay, we're no longer going to go chasing after IT consultants and business consultants and try to prove that they're employees of the temporary staffing company. We're no longer going to do that. All you got to do is show us they're incorporated, they got a separate business arrangement, you got a contract, and you pay them by the hour and it's $60 an hour, we'll let it go. But that doesn't change anything with respect to anybody's determination around workers' compensation. That's entirely separate legislation. And the Workers' Compensation Board has always given a free ride to people that have been separately incorporated in real businesses. So just the fact that the Ontario government said we're not going to chase you anymore doesn't necessarily change anything with the Workers' Compensation Board. You probably might have been exempt already, but the change in the legislation doesn't, unless other circumstances change, doesn't change your exemption or failure to be exempt. So that's my fulsome and ambiguous answer to that question.
That was good discussion.
right.
I just have one question.
Sure.
The videos that are being recorded right now, are we going to be able to have them for further to look at them further, or is it just the course this way?
Beverly, the videos will be available to you. I'm Jennifer Traer in the office is responsible for that. She pushed record at the beginning, and I haven't seen her push unrecord or stop recording during our question and answer period. So even this part of it will be in the recording. Usually it takes a couple of days for us to get the recordings, download them from Zoom, upload them to a portal where you can have access to them in a format, but sometime in the reasonably very near future, you will receive an email giving you information on how to access those videos.
Excellent.
Okay.
Thank you.
Very good. Any other questions? All right, then. Going once, going twice, sold. This session for today is finished with 27 minutes to spare. That is a record. I think it's because I really zoomed through the first part. Usually I do the duplicate part a little bit slower, but really zoomed through it today. But same thing goes. My email address is steve.jones@bell.net. You can join me and friend me or something on LinkedIn. I'm not really super fast about accepting all those, but once or twice a month, I click through 100 or 200 acceptances of people. You can send me an email directly and ask me a question about anything to do with the topics that we've covered today. I am your facilitator for an upcoming session, which I think is next week, maybe on business ethics. During that session, we're also going to add in some special content for you that are going to cover the various forms of insurance that are available for employment agencies and staffing consultants, so that you can understand what's in those complicated contracts that the customers make you sign all the time. And we're going to go through the Access Code of Ethics and Standards. And I'm going to try to do it in a slightly different way. I don't like the slides that much because it talks a lot about what we should not do. I'm going to try to turn it into a real positive and talk about the things that we can do. And again, I want to remind you that in coming May, we're going to have of two things. We're going to have the conference held in Toronto. Please watch for invitations for that and try to find a way to go. It's the best thing you'll ever imagine. And hopefully I'm going to be a speaker there and running some sessions at that for you also. And finally, if you have not contacted Jennifer to set up a membership access password into the Access members area on accss.org, then please do that, because there's other resources available, notifications, and I think it ties together to their database to make sure that your email address is up to date, so that even in the future, if you change companies, quit jobs, move to a different province, you'll still continue to receive your notifications as an Access member, because we've got your updated email address. And with that, I want to say thank you very much. And I want to thank you for taking the initiative to sign up for your CPC. those people with professional designations of the certified personnel consultant significantly differentiate themselves in the marketplace. When you do get your CPC, you'll be able to put that on your business cards, on your email signatures. You'll be able to tell your customers and your candidates that you take your job seriously, that you are a professional, that you are committed to making a difference, to being different, to offering a higher level service. Hopefully it'll help you to make more money, to be more successful, to stay in the industry longer, to be happier, to avoid problems, and just in general be a better consultant across the board. So congratulations for making that choice, and we'll see you again next week.
Thank you. Have a good night.